Yes, good evening to everybody. Welcome to the today class of the law of insurance. I am seeing that the participants are joining. Let them join it so that I could continue it. Before I could continue it, I would like to see and hear whether you are hearing me or not. Yes, Narendra Raju, please, you can unmute and read what I posted on the screen so that I could know that you are with me. I am with you.
Good evening, sir.
Very evening, very evening. So what I posted on the screen.
You said good evening, sir.
Yes,
You
only that
posted
much.
good evening.
Good evening to
Okay.
students. Yeah.
Yes, sir. Yes, sir. Yes, sir.
What is flying there on the sky? In the sky?
I think they are birds, sir.
Yes, they are birds, but what their neck is very lengthy. Their legs are very lengthy. Then what kind of the bird they are?
That might be eagles, sir.
Eagles are in that way.
That might be cranes, sir.
Yeah, the crane type one it will be there. Yes, and yesterday that we dealt it the class responsibilities, isn't it? So
Yes,
now in
sir.
this class also we'll see what are the yesterday we dealt with the responsibility of the insurance agent. So now we will see the legal responsibility of an insurance agent. Even insurance agent also responsible. Is it or not?
Yes, sir.
Because principal is the insurance company. Agent is the agent. Principal and agent is there. Suppose the agent doing anything is doing for the sake of the principal only. So if agent is responsible, equally the principal is responsible because there is a vicarious liability is there. So let us see that introduction. Everyone makes mistakes. Yes. If no one man mistakes, then we are no more in existence. What do you say?
Yes, sir.
If Adam did not make a mistake, then we are no more in this world. If you believe in the mythology, if you believe in the scriptures, so mistakes is there because the God has given him. Don't go to that tree and eat that fruit. But they intentionally they what they did it because of the Eva is there, and he went over there and ate, and then he was descended. Okay, that all the things would be there. But anyway, what I want to say is to err is human being means human being only could err,
Hmm.
not angels. So that is what I want to say is so man makes the mistakes. It's a mistake is a common thing, but a man will make a mistake, but he would learn the lesson from the mistake and don't do the same thing which he did it earlier. So that's what I want to say. There is the application of the brain. So everyone makes the mistakes, and insurance agents are not immune. Even they are not immune because they did not have any other such a miracle. They could not do any mistakes. So the very complexity of the insurance business creates a numerous opportunity for errors. So there is a possibility there because human hand is there. The possibility there, the errors are there, and the omissions to creep into an agency operation. So if there are mistakes, it will creeps or crawl into the operations. So that is the point which I want to say is. So insurance agent malpractice suits. So agents follow the closely behind the doctors and lawyers as subject of increasing the number of claims alleging professional misconduct and negligence. So naturally, what will happen mostly these the lawyers and the doctors and they follow the closely the cases how it would be there. That means what it means, let me see it. Not only has the number of claims against the agents increased, but the size of the claims also increased as well. So naturally, there are many cases if the doctor makes a mistake because of the medical negligence. In the same manner, if the lawyers make a mistake, yes, the appearing mistake, not that he is winning and losing. At that time, he will also be liable for the professional misconduct, and a case also be filed against the Medical Council of India in the same manner, Bar Council of India. Yeah, not only has the number of the claims against the agents increased, but the size of the claims are increased as well also. Yes. The source of an insurance agent's legal responsibility. What would be the agent's responsibility would be there that we will see now. An insurance agent serves two masters, the insured, the one master, and the insurer, the another master. Because agent, naturally, he will obey the two masters. One is the person who is the policy holder, he has to listen to him. Another is the where he will get the commission, and that is the insurer, that is the company. In the context of this article, insured includes one who thought or he was insured. So here the insured means the policyholder, whether they were there or not. So the agent's legal responsibility to the client, how it can be. The client means he is the policyholder, arises out of it. Common law theories of negligence. Yes, suppose if he has given some wrong address, or if he not wrong address, the insured is given the correct address, but he wrote the wrong address, and something will goes wrong. Naturally, at that instance, the negligence on the part of the agent would be there. Then the insurance company would be liable because of the relationship of the vicarious liability, like a master and a servant, and a partner and other partners, and a principal and an agent. There is a certain relationship would be there. If the agent did any work, that means it's equally did by the master, that is the insurance company. So insurer. So the common law theories of negligence is there, number one, and number two, an implied contract to procure the insurance for the insured. So an implied contract to procure the insurance for the insured. So it means there would be a contract between the insured and the insurer. That means a policyholder and the company, which is going to be giving the insurance contract to the insured. So that is the responsibility to the client is concerned, and the agent's legal responsibility to the insurer. So here the client means customer, that is the policyholder. But here the responsibility to the insurer means the company under whom that he is working as an agent. Yes, number one, common law theories of negligence. Again, the negligence common law theory would be there. If you are negligent, would be there. Naturally, the master would be held liable because of the vicarious liability. In the same manner, if the agent is made a mistake at that instance, vicarious liability would be applicable. That means the insurer would be responsible. Yes. Number two, the written contract that ties the agency to the insurers. Yes, there is a contract. It is there, ties the agency to the insurance, because the insurer, the agency agent also a part of the insurance company, because they will get the commission as they will promote the business also, and there is a licensed one. Not merely everybody can make an agent. No, they are licensed one. The identity card will be issued over there. Sometimes the premium will be paid to the agent, only the agent will pay in the office outlet, the counter. That is the point. Yes. When you say the common law negligence, how the common law negligence will be coming over there? The negligence is different as the filing to do something, failing here, not filing, failing to do something that a reasonable and a prudent man would do, or doing something which is reasonable or a prudent person would not do. So, what is the reasonable, what is not reasonable, it will be seen a prudent man do, and a prudent man will not do it. So, a prudent man, when it is a anticipation of raining, what he will do? Yes,
He will
please.
bring an umbrella, sir.
He will take the umbrella. If the umbrella is not there, he will take the raincoat. If the raincoat is not there, yes, please tell me.
He will stay in home, sir.
But he wants to go out for the immediate work.
He will
Yeah.
go by auto, sir. He will go by taxi.
Yeah. But reaching to the taxi, but at the time that he will wet, no, by the time the rains. So at least reaching to the taxi, suppose there is no umbrella, there is no raincoat, that what he will wear?
Cap, sir. Rain cap.
The whole body will not be covered over there. I don't know whether you know it or గొంగలి కప్పుకొని కూడా పోతారు చూసారా మీరు ఎప్పుడన్నా
Yes, sir. Yes, sir.
గోనపట్ట
Plastic cover కూడా ఎత్తి
ప్లాస్టిక్ కవర్లు కూడా తలకాయ పెట్టుకుంటారు, అది తొడుక్కుంటారు. డిడ్ యు సీ ఇట్?
Yes, sir.
యా, ద ప్లాస్టిక్ కవర్, గొంగలో, బస్తానో ఏది లేకుండా కనీసం టవల్ అన్నీ వేసుకుపోతారు, ఎందుకంటే తలవద్దు.
Yes, sir.
Yeah. So a prudent man will do. So a prudent man will, at least he will cover the head by keeping the plastic bags. Of course, the plastic is banned in other countries. So he will keep at least the towel. Something would be there so that he will try to protect it. That the prudent man, because when the work is very much vast and he is supposed to go at that instance. Okay, because generally a prudent man, he will keep the umbrella with him. Because if he did not purchase it, he is going to purchase when the season comes like that. Even though it is not a big umbrella, it is a small at least, which is taken by their children's or by the wife who is the office. that is parasol, we'll say. We don't say umbrella, which is in color one, and the small one, color one, we will keep in the bag, in the purse. That colored one used by the woman is not umbrella. Don't say umbrella. Parasol, Parasol. Parasol means it's also umbrella, but taken mostly by the woman. It is the colored one and the short one, and especially women will take that is called the not the umbrella. It is called the parasol, Parasol. Though it is not there in the insurance laws, but I am giving you for the additional ideas because the reference has come over there, so I don't want to lose that chance. Yes, that's my point. So and that's why I tell you that a person who will not attend my class, who will miss my class, will miss many things. So meanwhile, sometimes I will remember you, I will tell you the same thing. Yes, come to the point. A prudent man is supposed to do, a prudent man not supposed to do, then definitely he will make it a particular point. So the criteria against which actions are measured. So what is the criteria should be taken, it should be measured, therefore are subject to the change over the time, and the prudent person against whom one is measured is intended to be a peer. The peer means friend. PEER, peer. తెలుసా అండి, తెలియదా?
Yes, sir, I know, sir.
Very good, very good. So it is clear from this definition of it is reference to a reasonably prudent agent. A prudent agent will be, he is a very diplomatic and he will try to satisfy both the master. One is the client, another is the insurer. Yes, there are the occasions of an insurance agent in a specific case will be examined and evaluated. So this is the occasion where the insurance agent in specifically case will be examined and evaluated based on the facts and circumstances involved in that case. So naturally, if the company want to grow it, that depends upon the agents. Because with the agents' efforts only, the company will make it out. Of course, agents also does it because they will get the commission. Yeah, the standard against which the agent will be measured depends upon the state of the art, because the agent will be very articulate. Did you see any agent who is a dumb? Yes,
No,
insurance
sir.
agent.
No, sir. That his
Because
duty is to
speak.
that his duty is to speak, sir.
His duty is to try to convince other people, try to trap it, convince him. Because of course he is convincing for our betterment only, no doubt for that regard. But his some share would be there, because his livelihood will also be there. Of course, somebody will not do for the livelihood, if somebody do for the hobby. It is for the hobby also there. So the standard against which the agent will be measured depends upon the state of the art, how the state of the art would be there, how he will convince this better based upon that thing. See, a prudent man means he will sell two combs to the bald head man. Did you understand? నేను చెప్పింది అర్థమైందండి ఇప్పుడు?
Yes, sir, understand.
ఏంటిది చెప్పండి, తెలుగులో చెప్పండి.
బట్టతల ఉన్నవాడికి 2 దువ్వెనలు అమ్మితే ఏమవుద్ది అని అడిగారు, సార్.
అంటే మరి ఎవడు ఇక్కడ ప్రూడెంట్ మ్యాన్?
వాడు అమ్మగలిగితే అమ్మేవాడు ప్రూడెంట్ మ్యాన్ కాకపోవచ్చు కదా, సార్. అంటే ఇక్కడ సేల్స్ పర్సన్, సార్.
ప్రూడెంట్ మ్యాన్ అంటే ఇక్కడ ఏజెంటే ప్రూడెంట్ మ్యాన్ ఇక్కడ. ఇది ఎగ్జాంపుల్ అమ్మేవాడే. ఎందుకంటే అంత మ్యాజిక్ చెప్తారు. అరే ఈ దువ్వను చూసుకున్నావు అనుకో, నీకు ఎట్లా తెలుసా మరి వెంట్రుకలు. So he will try to convince such a man, the bald man, instead of purchasing one, because మళ్ళీ రేపు అత్తనో రానో మళ్ళీ దొరకదో ఇది లక్కీ దువ్వేనా, దీని మీద మంత్రం ఉన్నది, దీని మీద అది ఉన్నది, ఇది ఉన్నది, ఫోటో చూపెట్టి మొత్తానికైతే వాన్ని అంట కడతారు 2 దువ్వెనలు. So the state of the art would be there. So an agent's duty and an insured, therefore, constant is evolving in this revolve, because his plan is that he should be see that the insurance company will get the sum of this of the holders, policy holders. So professional, and here the professional or salesperson is concerned. Yes, one implication of the definition of the negligence is that the higher and the level of experience, education, and skills involved, the higher the standard of the care against which action will be judged. There's an insurance agent who holds himself out to be a professional through the written or oral representations and appearances raises the standard of care against which the action will be judged. So how do you judge it whether he is a good salesman or not? Because they will make the interviews, They will make the vivas, a group discussions, then the personal interviews, then only after screening, then only they will take the candidates. For instance, if the multinational company come to the anybody, any colleges in the engineering colleges, that means they will truly they will take the only the cream. Are you following me? Yes.
So-called placements, huh?
Placements కి ప్లేస్మెంట్స్ కండి
అదే సార్ నేను అన్నది క్యాంప్ ఆఫ్ ప్లేస్మెంట్స్ అనేది దే విల్ అరేంజ్ అట్ కాలేజీలో.
యా వాళ్ళు ఎవరిని తీసుకుంటారు తెలుసా?
క్వాలిఫైడ్ మెరిట్ స్టూడెంట్స్.
ఓన్లీ క్రీమ్ అన్నా నేను. క్రీమ్ అంటే అర్థం
ఎక్సలెన్స్ ఫెలోస్.
దాన్నే అంటారు క్రీమ్ అంటారు. ఎస్ విల్ బి జడ్జ్ ఓవర్ దేర్. ద క్లయింట్ రిలేషన్షిప్ చూద్దాం ఇప్పుడు. In addition to an agents pursued the professionalism and established the course of the dealing or a special relationship with an insured. Insured means the person who is taking the policy holder, called insured, can affect the degree of the agent's legal responsibility to the insured. If an agent consistently renews the insurance policy for an insured over a period of years, for example, the agent has established a course of dealing and may then be held liable for failure to renew. An agent that counsels that insured needed to coverages, thereby then creating the special relationship with the insured as an insurance consultant. So client relationship here naturally, and every time that a policy holder never go to the insurance company office to pay the installments. At that instance, sometimes even the agent will comes to the house and he will collect the policy and he will see that that will be deposited the next day or the other day that he will submit the receipt also. So a good bond would be there between the client and the agent at that instance. And this sometimes no client will give some of the what I say some of the clients means the policy holders to the agent, because they also feel that because he's a relative, he's a well-wisher or he's a known person and his livelihood is merely on based on this one. So they try to convince it. So instead of convincing the agent, even the policy holder convince the other policy holder, other would be policy holders to see that they will take the policy from the particular agent, because they will say that this agent, if you make it out now, he will give a good amount of your the subsidy to you. In the subsidy means less premium that you can pay the first time. Otherwise, sometimes he will pay the entire premium in the first installment. Entire premium will be paid by the agent because he also gets something from there. Because he reaches the target, he will get the bonus. Yes, the course of dealing would be there. Such a relationship would be made by the client also. So under common law duties, an agent to its insured. What are the common law duties where the agent will be held responsible? So under common law, insurance agent owes a duty to use a degree of care and necessary to protect the interest of the insured. If the failure to use care results in the injury or damage to the insured, the agent can be held liable for the injury or the damage. Of course, the agency is also responsible for the negligent or the fraudulent acts of its employees and solicitors. Even the agency means the insurance company also equally liable, because as I already told you, there would be a relationship between them like a principal and agent and master and servant and partners and other partners. So a particular relationship is there where the vicarious liability will holds good. So vicarious liability would be held liable even though he himself did not involve the act, but indirectly that he involved the act. That is why you would say act, actual personalities. No, is it not? This is that's a personal action dies with the person is a different thing. So even though a agent did a particular work, but it is equally responsible that that the work was done by the its principal. So that is the relationship it will come over there on the common law. For the agent activity, the principal means the insurer is held liable. So the agent owed a legal duty to the plaintiff. Yes, the agent should be very much careful in taking the information, noting down the information. As I told you, utmost good faith. That is very much important from both the sides. So number two, there was a breach of the duty. Suppose if we did not follow such a duty, and by the agent, naturally that he will be held responsible. And the third, the damages suffered by the plaintiff are approximately caused by the breach of duty. So naturally they will see the proximate duty also there. Suppose if he beat him today and the bleeding should have to come today, but instead of bleeding coming today, the bleeding come after the 2 days later. Can you file a case against a particular person? If really there is a cut and there is a slit, there is an incision on the skin, then the bleeding should start at the time only. The bleeding will not start only after the 2 days later. When there is an incision or cut with a sharp knife or sharp blade. What I want to say. So the proximate cause means near cause should be there. సార్ ఇవాళ జోక్ చెప్పినాం అనుకోండి, ఎప్పుడు నవ్వాలండి? ఎస్,
Immediately you have to.
ఇమీడియట్లీ జోక్ ఎండ్ కాకముందేనే నవ్వు రావాలా, అర్థం చేసుకుంటే. అవునా అండి? ఎస్ సార్ నో?
Yes, sir.
Yes, sir.
ఇవాళ జోక్ చెప్పినా అనుకోండి, రేపు నవ్విండ్రు అనుకోండి మీరు,
అని చెవిటోడు అనుకుంటారు.
అంటే అర్థం అరే ఇప్పటి వరకు మంచిగానే ఉండేరా, ఇప్పుడు వీడు నవ్వుతాండి ఏందిరా అంటే, అరే ఎందుకు నవ్వుతారా ఒక్కనే అంటే సార్ నిన్న జోక్ చెప్పిండ్రా, నాకు అర్థం కాలే, ఇప్పుడు అర్థమైంది కాబట్టి నవ్వుతాన్నా. అవునా అండి? నవ్వనండి, కానీ కొంచెం పక్కకు చూసి నవ్వండి, ఎందుకంటే ఎవడన్నా చూస్తాడా లేదని చూడడానికి. అదర్వైజ్ అది రాంగ్ సిగ్నల్స్ పోతాయి. మళ్ళీ ఏమంటాడు తెలుసా, అరే పాపం ఇప్పటివరకు మంచిగానే ఉండే వీడు ఒక్కడే నవ్వుతానంటే వీడిని తీసుకుపోయి చక్కగా ఎక్కడ జాయిన్ చేయాలా, ఇది సనత్ నగర్ పోయే దారిలో చూడండి, ఏంటిది అది, ఎర్రగడ్డ, అమీర్పేట నుండి సనత్ నగర్ పోయే దారిలో వస్తుందా రాదండి ఎర్రగడ్డ? సార్ మేము ఎప్పుడు పోలేదు సార్ అటు. No, I'm seeing that. So a prudent man never see a prudent man supposed to do in such a way, and he will do the proximity would be there in the common law, so agent would be held responsible. So generally do to act reasonably. So whenever a person is acting, he should act very reasonably. An agent generally has a duty to act as a reasonably prudent agent and would act in the same or similar circumstances. That is the of course I copied from the different place. That's why it is said in Texas. Any other place, because insurance principle is the same anywhere in the world. Of course, variation would be there slight depending upon the nature of the contract is concerned. Yes, now the question, a prudent man, మీరు చెట్టు కొడతాను అనుకోండి, కొమ్మను కొట్టాలంటే ఇప్పుడు ఎటు కూర్చొని కొట్టాలండి? కొమ్మకు అవతల దిక్కు కూర్చొని కొట్టాలనా, యువతల దిక్కు వచ్చి కొట్టాలనా కొమ్మ కొట్టాలంటే? కాండము ఏది మన దాని ఉంటది, ట్రంక్ దగ్గర కూర్చొని కొట్టాలా, కానీ అవతల దిక్కు కొట్టద్దు, కొండ చివర, ఇది కొమ్మ చివర కూర్చొని కొమ్మను కొట్టద్దు.
కొమ్మతో పాటు మనం పడిపోతాం.
ఏ ప్రూడెంట్ మ్యాన్ నెవర్ డూ సచ్ ఎ థింగ్. అరే ఎందుకు కొడుతున్నారు అట్లా, అరే చూస్తా పడతానా పడానా అండి, చూస్తాడా అండి, పడాడా అండి? Why do you do such an experiment?
You should fall down.
Definitely, because the Newton's principle is there. One should have to fall down, definitely. Whether injury is there, may not, that is a different issue. So, suppose he falls down on the sand, he will not get an injury. Suppose he falls down the rock, definitely he will get the injury. So, the institute looks at the agent, he deals with to get the coverage of the risk. How much the coverage of the risk also will count. With a sound company who can and will probably pay claims when they are due. It is a duty to keep his clients fully informed so that they can remain safely insured at all the times. So it is an agent duty, and he want to see that the client should immediately get the latest information. If anything will be increased over there, or a good amount is going to come, or some other thing will happen, definitely it should have to intimate to the insured. So that is the thing where the Trinity Universal Insurance Company versus Burnett, Texas company, 1977, they have given this case law. But you can cite any other case law. If the case law is not there, at least you should give an example, or you can explain with the illustration. That may be enough for time being to understand the things. So this general duty to act reasonably has been softened somewhat over the years by the various court decisions and described certain specific duties of the insurance agents. The following common legal theories of the errors and omissions claim illustrate the degree of the care recognized in the common law. So what is that degree of care should be taken in case of the errors are there, or omissions are there, or to overcome them? These are the points, bullet points are given here. Misrepresenting the insurance coverage. So one should not to give the misrepresent the insurance coverage. They have to actually say what should be covered or what should not be covered in that insurance. An insurance agent may misrepresent the existence of or extent of the coverage provided in that policy. So what is the things should be covered in this policy? We have to make it very much clear to the insured. Then otherwise, if he did not do so, it is against the norms of the the utmost good faith. Yes. Number two, failure to the procure requested insurance. So suppose the requested insurance would be there. If you did not procure it, that is a mishandling or inefficiency of your caliber, or inefficiency will be counted over there. That you will be labeled as an inefficient if you could not procure the requested insurance. So an insurance agent who undertakes to procure insurance for another owes a duty to use reasonable diligence and attempting to place the requested insurance. So on behalf of somebody also, if he wants to take it, then he has to convince the boss that yes, he is taking on behalf of so and so thing. At that instant, the insurance will be applied, given to him, or given to the policy holder, or made to the policy holder. So now the third point is failure to notify the insured of inability to procure insurance. So failure to notify insured inability. So if you want to show some inability to the insured to procure the insurance, it is also deficiency would be there. So as an expansion of the above theory, an insurance agent owes a duty. So insurance agent owes a duty to inform the insured promptly if unable to place the requested insurance. Suppose if he could not make the requested insurance, what is the insured wants? But he can say that these are the difficulties would be there, and hence I could not procure that one. But instead of that, I got this one. It is also equally important, and in one way, in another way, also it is a good. So he has to convince it, and he has to show the reason. మనం అంటామండి, అందని ద్రాక్ష పండ్లు పులుపన, అందని ద్రాక్ష పండ్లు పులుపునా పులుప. ఎస్,
ఫుల్ అని అంటారు. అందరం దాచిపెట్టి ఫుల్ అని అంటారు.
అల్లరి దాలక్షరి పున్నాను ఎందుకంటామండి?
అందరూ కాబట్టి అనుకుంటారు.
మనస్సుకు శాంతి పరుచుకుందా అని చెప్పుకోవాలి అన్ని. టు కన్సోల్ యువర్ ఫెయిల్యూర్, టు కన్సోల్ ద థింగ్. ఇక పుల్లగున్న ఎవడు దేవుతారా పోని. సో అట్లీస్ట్ ఇఫ్ యూ ఫీల్ లైక్ దట్, యూ విల్ ఫీల్ కంఫర్టబుల్. సో ఇట్ ఈస్ యాటిట్యూడ్ యూ హ్యావ్ టు డెవలప్ ఇన్ దట్ వే. ఆర్ యూ ఫాలోయింగ్ మీ? Yes. Next point, procurement of inadequate coverage. So inadequate coverage, one should not to make it out. So an insurance agent who agrees to provide the insurance to an insured owes a duty to use reasonable care to obtain the adequate insurance to meet the insured needs. So whatever the insurance needs would be there, with that the insured has made the insurance, so adequate amount should have to be given to him or paid to him. That he has to fight against his boss, that is the insurer. Yes, failure to maintain the requested insurance. So whatever the request should be there, if you fail to make certain request insurance, the insurance agent owes a duty to inform the insured when the renewal policy contains the coverage changes. So whenever the renewal would be there, whenever the policy will be changed, whenever the installment will be increased, this should be brought to the notice of the insured. So failure to inform the insured of renewal, even that also comes. If the renewal is there, if you did not inform him, then naturally that he will be loser. For instance, motor vehicle insurance is there, and if the agent is made for you, the next day, next time also he will come 1 week before only. Sir, your motor vehicle insurance is there, renewal is there, and hence if you pay this money, then I will go and see that it will be paid to you. That's why they will do the services also, because when they do the services, naturally they do have some commission in it. So failure to investigate an insurer's financial solvency. Yes, failure to investigate an insurer's financial solvency. Suppose a company is going to be wind up, or going to be become insolvent, or become the financially crushed down. At that instance, you have to tell to the insured that yes, this company they try to withdraw or try to make the early possible way to remove your or take back your money. So that is the duty of the agent to see that the insured should have to be not on the roads. An insurance agent owes a duty to place a coverage with the solvent insurer reasonably money for any insurer's financial conditions, disclose solvency information to the insured if it is so, and protect the insured when the risk of insolvency becomes so great or too great. So when there is a probability would be there, and you have to make it out. That's the reason we will say that is a stitch in time, I repeat, a stitch in time saves 9. So if you stitch it in time, so you need not to stitch 9 times over the stitches over there, because one stitch is enough at the time in the beginning. So prevention is better than cure. There is another way. Yes, Yes, this is the coverage customer. Duty to explain the policy terms. Yes, answer is yes, definitely that he has to explain the policy terms. The duty of it there for the agent. Yes, does an agent have a duty to explain the policy terms and coverages to customer? Answer is yes. So generally the courts have said the answer to those questions is no. Because they should say yes because it's the duty of him. సార్ అది మీకు ఇచ్చేసినా సార్ మీరే చదువుకోవాలా. దర్ ఇస్ a different issue. As is the case with the most EOs, this means yeah, the boss. See, like CEOs, the EOs. What is the full form of the EOs? O means officer, executing officer.
Or
Yes.
enquiry officer may be called.
Pardon?
Either enquiry officer or executive officer also it will be used for the
Yeah, in
CEO.
the both the way it can be used over there. So in the most EO has loss exposure and in such a time he should not inform. However, an agent can get sued for the failing to explain offer coverage even if there is no legal duty to do so because based on the previous court decisions, that's why loss prevention measures are so important. So try to reduce the loss if you know it. That is the very important. So client relationship can affect the success or failure of the client's claim against the agency. Yes, and establish a special relationship with an insured can affect the degree of the agent's legal responsibility to the insured. So if the agent is so articulate, so smart, definitely we'll see that the insured will be paid the insurance amount from the insurer. Yeah. If an agent counsels the insured on the policy terms and needed coverage, for example, a judge or a jury may say that the agent has established a special relationship with the client and may hold the agent liable for the failing to explain the coverage or exclusion or for the failing to mention to coverage that the insured does not have at the time of the loss. So it is the duty of the agent to see that the all coverages should be borne or paid to the insured. And if it is not paid over there, naturally it should also bring to the notice of the insurer. Thus way the amount would be paid. Without this special relationship, however, the court have fairly consistently refused to blame agent for a policyholder's failure to read and understand his or her policy for not providing the coverage for every conceivable loss. So whatever the coverage is not given over by the agent, naturally that will be the coverage should be paid, the penalty would be paid, the coverage should be paid by the insurer. So that was the thing which I want to share with you. And later duties to an agent we'll see tomorrow because today that duties, yeah, only few duties are there. I can finish it because the still time is there. Yes. Does an agent have a duty to explain the policy terms and coverages to customers? Does an agent have a duty to offer higher limits of additional coverage? Generally, the courts have said the answer to this question is no, but the answer is yes. It is the duty on them to make them coverage very much clear and the duty on them to disclose everything. The client relationship can affect the success of the failure of the client's claim against the agency. So naturally, agent also very important whether the client's claim would be getting there or not because he knows the technicalities how to get it. An established special relationship with an insured can affect the degree of the agent's legal responsibility to the insured. Yes, there is a responsibility of them would be there. They will take care of it and see that the agent will take the advantage of it and explain the insured should have to get the full amount of the coverage. If an agent counsels are insured on the policy terms and needed the coverages, for example, a judge or a jury may say that the agent has established a special relationship, yes, with the client and may hold the agent liable for the failing to explain the coverage or exclusions for the failing to mention the coverage that the insured does not have the time of the losses. So if there is a relationship would be there quite good, then the responsibility definitely fall on the agent because he failed to inform certain coverage areas. Yeah, that the thing will come. So a special relationship, however, the courts have fairly consistently refused to blame the agent for a policyholder's failure. Sometimes even policyholder failure would be there because he is not taking the utmost care to inform to the agent his problems. Failure to read and understand also is one of the factor. Even the policyholder could not read it and explain to them, and they could not understand the language. Even though the agent will explain very clearly what is the terms and conditions are written over there in the certificate of insurance that is called bond in other words. So the failure means without education, the policy holder would be there and who could not understand his or her policy for not providing the coverage for every conceivable loss. So whatever the loss would be covered there, whether it's covered or not covered, it is not clearly mentioned. If it is mentioned also, the policy holder could not read because she or he is uneducated. So duties of an agent to its company. Yes, the equal duty would be there for the company also. The agent has to make it out. The agency company contract creates a special relationship again between the agent and the insurer, thereby increasing the required degree of care. In addition, an agent has a fiduciary relationship with an insurer that requires an extraordinary degree of care. Yes, because there is extraordinary degree of the care would be there because the strong bond is strong between the principal and the agent. Here, the insurer and the agent. An agent's duty of care to an insurer is illustrated in the following common law types of errors. Some like making the mistakes, failure to follow the company instructions, and failing to disclose the information, delay in forwarding the information, exceeding the express or implied authority the company gives the agent. So these are the certain factors would be there where we can throw light on it. By that, we can finish this thing. So I would like to finish today because at the 6 o'clock, I have to be one of the speaker in the SFI's function. That is the 65th death anniversary of the Dr. Uh, Baba Sahab Ambedkar's death anniversary. Actually, it is tomorrow, but there are a lot of programs of tomorrow. That's why they preponed it. In the 6 o'clock, I will put the link. If anybody is interested, please take the advantage of here to attend the webinar. That depends upon you. With this, I would like to close down my things. Thank you very much for your patient listening, and we'll meet you tomorrow. Tomorrow is Sunday. So if the Sunday is the public holiday, please spend the time with your family, children, and do the household work and help the household chores and see that everybody would be happy and spend with your elders because your parents are there. You are good enough. Spend the time with your parents and children and your wife. And with this, I will stop it and will close it. Yes, end of the meeting. Thank you very much.